So it's sort of the major questions doctrine is kind of a subset of the non-delegation doctrine. Would that be fair?
I think, yes, that would.
And basically, the major questions doctrine just says, look, Congress can give a regulatory agency, the executive branch, power over a major.
Welcome back to Freedom Forge, the channel where we stand for faith, freedom, the Constitution, and the principles that made America the strongest and freest nation on earth. If you believe judges should know the Constitution inside and out, if you believe Congress should write the laws instead of unelected bureaucrats, and if you enjoy honest analysis of the biggest hearings taking place in Washington, make sure you hit that like button, subscribe to Freedom Forge, and turn on notifications so you never miss our latest coverage. Today's Senate hearing focused on one of the most important responsibilities the United States Senate has: questioning a federal judicial nominee before confirming that person to a lifetime position on the federal bench. Senators pressed the nominee on constitutional law, the separation of powers, the non-delegation doctrine, the major questions doctrine, suspect classifications, equal protection, and the role of the Supreme Court. What began as a technical legal discussion quickly turned into a revealing moment about how prepared judicial nominees should be before they receive one of the most powerful appointments in the country.
Judge Byrne, you were here when Senator Lee talked about the non-delegation doctrine.
I was.
Yeah, I got a little confused. What is the non-delegation doctrine?
The non-delegation doctrine refers to the idea that Congress may not give or delegate its lawmaking authority to an...
I'm sorry.
It's okay. The idea that Congress may not give or delegate its lawmaking authority to a regulatory body, that the legislative
Can't give
power...
it to anybody, can it?
Sure, anyone.
Can't give it to another branch of government, right?
Correct.
Okay. And what does that have to do with the major questions doctrine?
I mean, Senator Lee certainly explored some overlap between the two. I had not actually considered personally the overlap between the two, but I think I can see some relationship. The major questions doctrine is a little bit different. It is a approach the Supreme Court and some other courts have applied in analyzing statutes, in essentially reaching the conclusion that Congress would not give broad rulemaking authority to an agency just based on a few words or a short ambiguous phrase. The idea is that if Congress is granting agency rulemaking authority, it would be clear in doing so. And to the extent that a statute isn't clear in that respect, the courts can sometimes potentially find that the major questions doctrine was violated.
So it's sort of the major questions doctrine is kind of a subset of the non-delegation doctrine. Would that be fair?
I think, yes, that would.
And basically, the major questions doctrine just says, look, Congress can give a regulatory agency, the executive branch, power over a major question of social significance. But if Congress is going to do it, they've got to be clear. They've got to say it big as Dallas. They can't just imply it, all right?
That's correct, Senator.
Okay. All right, we cleared that up. Tell me what a suspect classification is and how you get to be one. Suppose I want to be a suspect classification. What do I have to do?
Well, suspect classification wouldn't necessarily refer to a person, but rather to the idea that in different contexts it would be inappropriate to treat people differently based on a suspect's character.
But what to get to be a suspect classification or part of one? I agree with you. It's not just a person. What requirements do you have to meet?
Senator, I'm not sure exactly what requirements you're referring to, but there would be different examples, such as treating someone different based on race or sex.
I know. Race and lineage, ethnic origin. But, I mean, did the Supreme Court just pick those out of the air?
Well, certainly there are statutes that protect
No,
Those-
no,
and
they didn't
also
do it
the-
on statute.
Well, the Constitution prohibits the government from treating people differently
Yeah, but
based
the
on.
Constitution doesn't say these are the people. The Constitution doesn't define suspect classification. Supreme Court did that, right?
I think that's correct.
Okay. And y- if I'm for the court arguing that a particular group is a suspect classification, what are the definitions? What are the characteristics I'm going to use to define? One's a history of discrimination, right?
Yes.
Gotta show
A
that.
history of discrimination. I think immutable characteristics.
Mutable characteristic, bingo, that's right.
Right.
An absence of political power, right?
I believe the court has discussed that, yes.
Yeah. And that an immutable characteristic which doesn't affect my ability or the suspect classification's ability to contribute to society, right?
That's correct.
Right? And what are the suspect classifications?
What are they?
Yeah,
Senator, I'm not sure if I could provide a list.
there are only two. Race,
Race and
ethnic origin.
sex, ethnic origin, okay.
How come sex isn't a fully suspect classification? I mean, you got, women have a history of discrimination. It's an immutable characteristic unless you go get a sex change operation. Traditionally, they've been politically disadvantaged, and being a woman has nothing to do with your merit or your ability to contribute to society. So how come gender isn't a suspect classification?
Senator, I'm sorry, but I don't remember the specific case, if there was one, when the court would discuss that issue or analyze
Do you think
it.
they ought to be?
Certainly,
Is that a
women.
gavel I hear? Is that like a slight tapping I hear? Go ahead, can he finish answering?
Give an answer, and then we want to quickly go to Blumenthal.
Thank you, Chair. Certainly, women should be protected from discrimination. It's important to have laws of that nature. As to whether they should be deemed to be a suspect classification in the specific context you're talking about, if that has not already been decided by the court, it would be inappropriate for me to give, I guess, an advisory opinion on that issue. But women certainly should not be subject to discrimination or different treatment by the government.
Okay.
Watching this exchange, one thing became impossible to ignore. The American people expect federal judges to possess a deep understanding of constitutional principles before they are entrusted with interpreting the Constitution for generations to come. This isn't just another government job. A federal judge doesn't serve 4 years. They don't answer directly to voters. They aren't easily removed. They can influence constitutional interpretation for decades. That is why these hearings matter. Now, Senator John Kennedy has developed a reputation over the years for asking straightforward constitutional questions that often expose whether nominees have truly mastered the legal doctrines they will eventually apply from the bench. Some people criticize his style. I don't. In fact, I think this is exactly what advice and consent is supposed to look like. The Constitution gives the Senate the responsibility to examine nominees carefully. If a nominee cannot comfortably explain foundational constitutional concepts, senators have every right to ask tougher questions. The hearing began with discussion of the non-delegation doctrine. Now, for people watching at home who may not have attended law school, this can sound incredibly technical, but it's actually one of the most important constitutional principles in modern government. The basic idea is simple. Congress writes the laws. The executive branch enforces the laws. The courts interpret the laws. Those aren't merely suggestions. That's the constitutional structure our founders created because they understood that concentrating power in one place eventually destroys liberty. The non-delegation doctrine exists because Congress cannot simply hand over its legislative authority whenever writing difficult laws becomes inconvenient. And frankly, this issue matters more today than perhaps at any point in modern American history. Look around Washington. Thousands upon thousands of regulations affect nearly every aspect of American life. Businesses, farmers, truck drivers, manufacturers, energy companies, parents, schools, healthcare providers, small business owners. Most Americans couldn't possibly identify the bureaucrats who wrote many of those regulations. Yet those regulations carry the force of law. That should concern every citizen regardless of political party. Senator Kennedy then moved into discussing the major questions doctrine. Again, this sounds complicated, but the concept is remarkably common sense. If Congress intends to give an executive agency enormous authority over major issues affecting the entire country, Congress needs to say so clearly, not vaguely, not indirectly, not hidden inside a few ambiguous words buried hundreds of pages in a legislation. Congress should speak plainly. Why? Because major policy decisions belong to elected lawmakers who answer to voters, not career bureaucrats who never appear on the ballot. This doctrine has become increasingly important because federal agencies have grown tremendously over the last several decades. Whether you're talking about environmental regulations, workplace rules, healthcare mandates, education policy, banking oversight, or countless other issues, agencies now exercise enormous influence over daily American life. Many conservatives have argued that this expansion has upset the constitutional balance intended by the founders. That doesn't mean agencies serve no purpose. Of course they do. Government requires expertise. But expertise cannot replace democratic accountability. That distinction matters. One thing I found interesting during this hearing was that the nominee generally understood these doctrines, but occasionally struggled to explain the relationship between them. To be fair, constitutional law is complicated. Even experienced attorneys sometimes disagree about legal theories. But here's where expectations become higher. Federal judges are expected to interpret these doctrines, not simply recognize their names. Americans deserve judges who can explain constitutional principles confidently, because eventually they'll be issuing opinions that shape constitutional rights for millions of people. Then the hearing shifted toward equal protection and suspect classifications. This portion of the exchange became even more revealing. Senator Kennedy asked what qualifies a group as a suspect classification. Again, for viewers unfamiliar with constitutional law, here's why this matters. When government treats people differently based upon certain characteristics, courts apply different levels of constitutional scrutiny. Some classifications receive the highest level of judicial protection. Others receive less. Determining which category applies can affect the outcome of major constitutional cases involving civil rights, education, employment, and government policy. Kennedy wasn't simply asking trivia. He was testing whether the nominee understood the constitutional framework behind equal protection analysis. Eventually, the nominee identified several factors discussed by Supreme Court precedent, including a history of discrimination, immutable characteristics, political powerlessness, and whether the characteristic affects one's ability to contribute to society. Those are important concepts because they have appeared repeatedly throughout decades of constitutional litigation. Then came perhaps the most interesting moment of the hearing. Senator Kennedy asked why sex is not considered a fully suspect classification under Supreme Court doctrine. Notice what happened next. Rather than offering a personal opinion, the nominee declined to provide what he described as an advisory opinion. Some viewers will see that as avoiding the question. Others will view it as respecting judicial ethics. Federal judicial nominees frequently refuse to answer hypothetical legal questions because they may eventually preside over similar cases. That's been true across Republican and Democratic administrations alike. Whether one agrees with that practice is another discussion entirely. Personally, I understand why nominees avoid predicting future rulings. Judges shouldn't campaign for the bench by announcing how they'll decide future cases. That would undermine confidence in judicial impartiality. At the same time, senators also have a legitimate responsibility to evaluate a nominee's constitutional philosophy. Balancing those two concerns is never easy. Here's the larger issue that conservatives have been raising for years. The federal judiciary has become extraordinarily powerful. Judges increasingly decide questions involving elections, immigration, religious liberty, gun rights, free speech, environmental policy, healthcare, education, and executive authority. When judges possess that much influence, Americans should expect extraordinary constitutional knowledge from every nominee. That's not asking too much. It's asking exactly enough. Lifetime appointments require lifetime-level preparation. Another point worth discussing is why constitutional structure matters so much. Some people dismiss debates over separation of powers as academic. They're anything but. Every time Congress transfers more policymaking responsibility to executive agencies, voters lose some direct influence over national policy. Instead of persuading elected representatives, citizens increasingly find themselves subject to decisions made by regulators they've never heard of. That's precisely why many constitutional conservatives continue emphasizing original constitutional design. Limited government isn't simply a slogan. It's a safeguard against concentrated power. Checks and balances weren't created because the founders trusted government. They were created because the founders understood human nature. Power accumulates. Power expands. Power rarely limits itself voluntarily. Our constitutional framework exists to restrain government before liberty disappears. That remains just as relevant today as it was in 1787. Watching this hearing also reminds us why Senate confirmations deserve public attention. Too often Americans focus only on presidential elections, but federal judges may remain on the bench for 30 or 40 years. Their decisions often outlast multiple presidents and dozens of congressional elections. These hearings shape the future of constitutional interpretation long after today's political headlines disappear. Whether you supported this nominee or not, Americans should appreciate senators who ask substantive constitutional questions instead of treating confirmation hearings like scripted political theater. Voters deserve transparency. They deserve to know how prepared nominees are before lifetime appointments become permanent. That's how constitutional accountability works. At Freedom Forge, we'll continue covering these hearings because they affect every American, whether they realize it or not. The Constitution isn't just an old document stored behind glass. It's the framework that protects free speech, religious liberty, due process, private property, equal protection, and the separation of powers that keeps government from becoming too powerful. Every judicial confirmation is ultimately about preserving or reshaping that framework. And that's why these exchanges matter far beyond Washington. They matter to every parent raising children, every business owner trying to comply with federal regulations, every worker relying on constitutional protections, every American who believes government should remain accountable to the people. Thanks for watching Freedom Forge. If you believe constitutional knowledge matters, if you believe judges should faithfully interpret the Constitution rather than rewrite it, and if you want more in-depth analysis of the biggest hearings taking place in Washington, don't forget to like this video, subscribe to Freedom Forge, and share this video with someone who believes America's constitutional principles are worth defending. Let us know in the comments. Do you think federal judicial nominees should be expected to answer detailed constitutional questions during confirmation hearings? Or are they right to avoid discussing issues that could come before the courts in the future? I look forward to reading your thoughts, and I'll see you in the next video.